I have seen legal frameworks collapse before, not through dramatic announcements, not through single decisive rulings, through the quiet installation of a new standard that makes the old system indefensible. On June 23, 2022, the Supreme Court issued its decision in New York State Rifle and Pistol Association versus Bruen. The case concerned concealed carry permits. The ruling mentioned assault weapons exactly 0 times, but within 18 months, that decision had destabilized every assault weapon ban in the United States. Not because the court struck them down directly, because it changed the test that courts must use to evaluate them. And under that test, these bans cannot survive. 7 states currently prohibit civilians from purchasing semi-automatic rifles with certain features. California, Connecticut, Hawaii, Illinois, Maryland, Massachusetts, and New York all maintain laws that classify firearms as assault weapons based on characteristics like pistol grips, folding stocks, and detachable magazines. Collectively, these jurisdictions represent approximately 94 million residents. The AR-15 platform is the most commonly owned rifle in America. Estimates place the number between 20 and 24 million units in civilian hands as of 2024. When you account for all firearms classified as assault weapons under state statutes, ownership exceeds 40 million. This is not a fringe weapon. This is a common arm owned by millions of law-abiding Americans for self-defense, hunting, and sport shooting. The Supreme Court has repeatedly stated that the Second Amendment protects arms in common use for lawful purposes. That principle was established in District of Columbia versus Heller in 2008 and embedded directly into the Bruen framework. But Bruen did more than reaffirm common use. It established a mandatory historical test. When the government seeks to regulate firearms, it must now demonstrate that the regulation is consistent with the nation's historical tradition of firearm regulation. Not similar, not analogous in spirit, consistent. The government must identify well-established and representative historical precedents showing that the type of restriction being imposed aligns with how the founding generation understood the limits of the right to keep and bear arms. This test does not ask whether a modern regulation serves a compelling government interest. It does not balance public safety against constitutional rights. It does not defer to legislative judgments about what policies might reduce violence. It asks one question: is there a historical tradition supporting this type of restriction? If the answer is no, the regulation fails. State attorneys, general defending assault weapon bans now face an impossible task. They must find historical evidence that the founding generation prohibited entire categories of firearms based on mechanical features. That evidence does not exist, because those regulations were never imposed. The term assault weapon did not enter American legal vocabulary until 1989, when California passed legislation in response to a schoolyard shooting in Stockton. The federal assault weapons ban followed in 1994 and expired in 2004. Every state-level ban currently in effect was passed after 1989. These are modern policy innovations with no roots in the founding era, no precedent in Reconstruction, no analogs in the 19th century. State lawyers have tried to argue that historical laws disarming dangerous individuals provide a relevant tradition. They point to colonial-era statutes that prohibited loyalists from possessing arms during the Revolutionary War. They cite Reconstruction laws that disarmed formerly enslaved people in southern states. They reference mental health commitments and felony convictions as long-standing bases for firearm prohibitions. But those precedents all involve disarming specific individuals based on conduct or status. They do not involve banning entire categories of firearms from the general population. The historical tradition is about who can bear arms, not about which arms can be borne. Attorneys defending these bans argue that founding-era governments prohibited dangerous and unusual weapons. They cite laws against concealed dirks and Bowie knives. But the AR-15 is neither dangerous nor unusual in the constitutional sense. It is not more lethal than other semi-automatic rifles. The features that classify it as an assault weapon, pistol grips, adjustable stocks, flash suppressors, are ergonomic characteristics that do not alter fundamental operation. 20 million units in civilian hands is the opposite of unusual. The Supreme Court said in Heller that the test is not whether alternatives exist. The test is whether the arm itself is in common use for lawful purposes. Federal courts are already beginning to apply the Bruen framework to assault weapon bans. In November 2023, a district judge in Illinois issued a preliminary injunction blocking enforcement of that state's newly passed assault weapon ban. The judge found that the state had failed to identify any historical tradition supporting the prohibition. Illinois appealed to the Seventh Circuit, where the case remains as of early 2025. In oral arguments, appellate judges expressed skepticism that the state could meet the historical test, with one judge noting that the government's evidence consisted primarily of 20th century regulations that postdated the founding era by over a century. California's assault weapon ban is being challenged in multiple cases. The most prominent is Miller versus Bonta, which has been working through the Ninth Circuit since 2019. In 2021, a district judge struck down California's ban, calling it a failed experiment that criminalized firearms owned by millions of Americans. The Ninth Circuit reversed that decision, but it did so before Bruen was decided. The case has now been remanded back to the district court with instructions to reconsider under the new historical framework. Legal analysts expect the district court to again strike down the ban, setting up another appellate battle that could reach the Supreme Court within 2 years. Maryland's ban is being challenged in Bianchi versus Frosch, a case that has been in litigation since 2013. After Bruen, the Fourth Circuit held the case in abeyance, waiting for further Supreme Court guidance. In late 2024, the district court issued a new opinion finding that Maryland's ban could not survive the historical test. The state immediately appealed. That case is now on an expedited track toward the Fourth Circuit, with oral arguments scheduled for mid-2025. Massachusetts, Connecticut, and New York all face similar challenges. Each state has attempted to defend its ban by arguing that assault weapons are uniquely dangerous in mass shooting scenarios. They cite FBI data on active shooter incidents. They reference casualty counts from specific tragedies. They argue that the capacity for rapid fire with detachable magazines creates heightened public safety risks. But none of that evidence addresses the historical question that Bruen requires. The question is not whether these firearms could be misused. The question is whether there is a historical tradition of banning them. The concern extends beyond state laws to municipal ordinances in Chicago, Boston, and San Francisco, but the larger concern is the domino effect. If a federal appeals court strikes down an assault weapon ban and the Supreme Court declines review, that precedent becomes binding in that circuit. The historical tradition either exists or it does not. If the Fourth Circuit rules that Maryland's ban fails the historical test, the argument supporting California's or Illinois' ban does not change. The same historical record applies nationwide. This is why a single strong appellate ruling could destabilize all 7 state bans simultaneously, not through direct legal force, but through the collapse of the only viable defense. Once one circuit court conducts the historical analysis and concludes that no tradition supports these bans, every other circuit faces the same analytical pathway. State attorneys general can try to distinguish their statutes based on minor differences in how assault weapons are defined, but the core question remains unchanged. If there is no founding era or Reconstruction era precedent for banning firearms based on cosmetic features, then no state ban survives. The timeline for this process is compressing. In early 2024, there were 6 active federal cases challenging assault weapon bans. As of February 2025, there are 14. The increase reflects strategic litigation by Second Amendment organizations that recognize the opportunity Bruen has created. These groups are filing cases in multiple circuits simultaneously, ensuring that the issue reaches appellate courts on parallel tracks. The goal is to generate circuit splits that force the Supreme Court to intervene, or alternatively, to produce a circuit ruling so well-reasoned that other circuits adopt it without further litigation. Gun control advocacy organizations have recognized the threat. Everytown for Gun Safety, Giffords Law Center, and the Brady Campaign have filed amicus briefs urging courts to interpret Bruen narrowly. They argue the historical test should allow analogical reasoning, not perfect matches. They suggest founding-era restrictions on dangerous weapons provide sufficient tradition to uphold modern bans. But those arguments face a fundamental problem. Bruen explicitly rejected interest balancing. Justice Thomas stated that the Second Amendment's text and historical understanding, not judicial assessments of policy effectiveness, determine the scope of the right. If courts cannot weigh public safety benefits against constitutional burdens, then the fact that assault weapon bans might prevent some mass shootings becomes legally irrelevant. Justice Thomas wrote over 80 pages explaining why proper cause, requirements for concealed carry permits failed the historical test. He examined colonial laws, state constitutions, Reconstruction statutes, and 19th century regulations. He found no tradition of allowing government officials to deny firearm permits based on discretionary assessments of need. That same analysis applies to assault weapon bans. If there is no tradition of prohibiting common firearms based on features that do not alter their fundamental function, the bans cannot stand. The political implications are considerable. 7 state legislatures passed these bans with strong public support after high-profile mass shootings. If federal courts strike them down, elected officials will face intense pressure to respond. But there is no legislative response available. Bruen does not permit states to rewrite their bans with different language. It requires historical tradition, and that tradition either exists or it does not. Some state officials have suggested that they will simply refuse to comply with adverse rulings. They have indicated that they will continue enforcing assault weapon bans even if courts issue injunctions. That approach invites constitutional crisis. Federal judges have the authority to hold state officials in contempt. They can issue fines, impose sanctions, and in extreme cases, order arrests for defying court orders. The prospect of elected attorneys general facing contempt proceedings for enforcing state law creates a direct conflict between state sovereignty and federal judicial authority. But even if states comply with adverse rulings, the operational challenges are immense. California alone has over 1 million firearms registered as assault weapons under its current ban. If the ban is struck down, does registration remain enforceable? Do owners receive compensation for having been forced to register? Can they modify their firearms back to prohibited configurations that are now constitutionally protected? These questions have no clear answers, and state agencies are not prepared to administer the transition. The economic impact will also be significant. Firearm manufacturers have designed entire product lines around compliance with state assault weapon bans. They produce California-compliant rifles with fixed magazines, New York-compliant rifles without pistol grips, and Massachusetts-compliant rifles with modified stocks. If those bans disappear, the market for compliant models collapses. Retailers have inventory, distributors have contracts, manufacturers have production schedules. The disruption cascades through the entire firearms industry. What happened after Bruen was not a single ruling that ended assault weapon bans. What happened was the installation of a legal standard that makes those bans indefensible. The historical tradition test is not a guideline, it is a requirement. And state governments cannot manufacture a tradition that never existed. They cannot point to founding-era laws that prohibited rifles with certain grips or stocks. They cannot cite Reconstruction statutes that banned firearms based on cosmetic features. The evidence is not ambiguous, it is absent. I have watched legal frameworks collapse this way before, not through dramatic confrontation, through the steady application of a standard that exposes structural weakness. The assault weapon bans in 7 states are not collapsing because of a single case. They are collapsing because the foundation they were built on, legislative discretion to balance rights against policy preferences, no longer exists. Bruen removed that foundation. What remains is a structure with nothing beneath it, and those structures do not stand for long.